and as always, the state is ready for trial. Obviously, further pre-trial issues, as detailed further in the pre-trial minute, might intervene, but in principle, we're ready to proceed. And the defense has got everything they need to commence their preparation for the trial. Then furthermore, if I could just update the court briefly about the appeals processes. The parties, I must say, the defense and I hope the state, were quite astute in sticking to the dates, so things moved along quickly as they should have. And I must express my appreciation to my learned friends for doing this. So let's just look at Tali's. Tali's immediately, on the 1st of November, filed their application to the Constitutional Court for direct access to the Constitutional Court. And by various dates passed by, but by the 15th of November 2019, last year, Tali's had filed their replying affidavit and the application to file that. So the proceedings, as it were, the pleadings in the Constitutional Court closed on the 15th of November last year, and so from that date we are waiting for further directions or orders from the Constitutional Court, either declining to take the appeal or to issue directions relating to the further conduct of the appeal in the Constitutional Court for Tali's. Then Mr. Zuma and Tali's, accused numbers 1 and 2, both filed their applications for leave to appeal to the Supreme Court of Appeal, the SCA. That was also done precipitately. 31st of October, Tali's filed their conditional application, and conditional on their appeal in the Constitutional Court being unsuccessful. And Mr. Zuma on the 1st of November filed his application in the High Court for leave to appeal to the SCA. So things were going along swimmingly. We, as the state, then commenced correspondence with Mr. Zuma's legal representatives, Mr. Muncher, and we said that we invite them to join Tali's in their direct application to the Constitutional Court, and we said that should they do so, we would not take the procedural point that they're cutting out the Supreme Court of Appeal. In other words, we would agree that the matter go directly to the Constitutional Court. Obviously, we would still oppose the appeal, but we thought that in doing so, it would cut out a whole series of appeals in the Supreme Court of Appeal. Obviously, if the Constitutional Court were prepared to hear us all, then that might cut out a whole. So we wrote to Tali's in detail, we wrote to Mr. Zuma in detail, inviting him to follow this route, and we received no reply from them, and they proceeded not to file any application in the Constitutional Court, but to proceed with their appeal in the, first of all, for leave to appeal in this court, and then after that to the Supreme Court of Appeal. So that will then indicate the steps that we took to try and curtail the appeals processes, unending processes of appeals to the various levels of courts going up to the Constitutional Court, but we were unsuccessful as far as Mr. Zuma was concerned in getting him to agree to do this. Right, and then after that abortive invitation, shall I say, this court, the full court, on the 22nd of November, heard the arguments, and on the 29th of November issued a judgment, the full court judgment, dismissing both parties' applications for leave to appeal in all respects. That's both the permanent stay aspects of both parties, and also the review part of the appeal against the review in respect of Tali's application. And Zuma and Tali's then proceeded to lodge their appeals for leave to appeal with the SCA. The dates we give here in a minute. Mr. Zuma on the 18th of December launched his application, and Tali's on the 20th of December, just before Christmas. Theirs was conditional on the Constitutional Court matter not being successful, and we filed our opposing answering affidavits early, I think a good month early, thus anticipating the dates of filing in the Supreme Court of Appeal. On the 21st of January 2020, we filed our answer, and Mr. Zuma very quickly filed his replying affidavit dated the 30th of January 2020, last week. So as far as the Supreme Court of Appeal is concerned, we are all now waiting for orders and directions from the Supreme Court of Appeal relating to the success of the application or otherwise, or further orders and directions from the Supreme Court of Appeal. So as we now sit, my lady, the pleadings are closed in respect of all the parties in all courts, the Supreme Court of Appeal, I should say both courts, Supreme Court of Appeal and the Constitutional Court, so we're waiting for directions from them. So we've done everything we can to expedite the process, and we expect to hear relatively early, we would hope, from both or either courts. Might I also just say, my lady, that we know, and this is elucidated in correspondence between us and discussions, we know that it is possible that Mr. Zuma, if he would be unsuccessful in his application to the Supreme Court of Appeal for leave to appeal, he may well, and he's indicated that he will, launch a further application for leave to appeal to the President of the Supreme Court of Appeal, special leave to appeal. That process has time periods which have to be adhered to and complied with. And should he then be unsuccessful, then a further application to the Constitutional Court lies, again with periods for the filing of papers, etc. So the appeals process, as far as both parties is concerned, has not yet been concluded, and there are further processes which have not yet been commenced. So that's where we are. If one has to estimate in terms of weeks, days or months how long it will be, well, that's how long is a piece of string, but we are reaching the end of that process in the appreciable future, as I would hope. Let's put it that way. My lady, let me then just address the court about some pre-trial management issues. We indicated to the court at the last provisional hearing on the 15th of October that we would commence such proceedings, even though the process, I suppose, as far as Mr. Zuma is concerned, has been suspended and it's premature. I'll get to that now. But let me just tell you what we've done. First of all, on the 15th of January, Mr. Zuma directed a letter to us to say that he would not be available to attend court today, and due to the fact that he would be attending to medical treatment abroad, as from the date was given, in January, the 23rd of January, until mid-March 2020. And furthermore, they requested our consent that the matter be postponed today to a holding date in April 2020. We replied that as far as the postponement of the matter to April is concerned, we don't have a problem. We will consent to that, because, but not on the basis of Mr. Zuma's illness at present, but because the appeals process in respect of all the parties has not yet been concluded, and we need that to conclude before we can start setting trial dates. And so we're happy with the date of April 2020. We're happy that it be a provisional date, but we did inform Mr. Zuma that his impending absence from court needs, let us say, further work. We don't simply accept a letter relating to the illness of an accused in general and treating all accused equally. We are obliged to interrogate that issue. And so in our letter of the 16th of January, we replied immediately to Mr. Zuma and said, please supply us with the relevant medical certificates so that we can formulate a position relating to what we're going to do about his absence from court. I'll address a brief argument to the court in this respect in due course. So this is what we told them, and this is under cover of a letter from the DPP of this division, asking Mr. Muncher to provide us with copies of the medical evidence that he would be presenting today or to us in advance, and we received no reply from Mr. Muncher to that letter. And we also asked them what about admissions and further pre-trial preparation, etc. And we in the interim, because of a question from the acting Judge President of this division to say what is going to happen today on the 4th of February, we informed the Judge President what the state of play was. The impending absence of Mr. Zuma and the pre-trial negotiations between the parties, etc. And we mentioned that in the pre-trial minute. Mr. Muncher replied that on the 22nd of January that he was unhappy that we'd written to the DJP, and he indicated that our invitation to him to start trial preparation by way of are they making admissions? What are we going to do about other pre-trial issues? Are we going to make other further pre-trial applications for further particulars, etc., etc.? He said on behalf of Mr. Zuma in this letter dated the 22nd of January that it was premature that such issues should be considered, and he said that in any case it was premature and his client has no financial resources to incur legal costs unnecessary. So the pre-trial process, which we attempted to start precipitately, has not been started on behalf of Mr. Zuma for the reasons which I've given. Tali's, our interactions with them have been somewhat more productive. I met with Mr. Roux, my learned friend, who's new counsel for Tali's for trial purposes. They introduced themselves to us. We discussed pre-trial issues, the various issues which are pending, which are possibilities.
Is Mr. Durand in court?
Mr. Durand is in court, and I'll bring an application that this court add in as the representative in terms of 33222.
Right.
So yes, and so we've received a request from Tali's to provide them with interim information so that they can respond properly to us. So there's negotiations, correspondence between the parties. We owe them an answer, and we owe them some analysis of information. So I submit that the time has been used productively with a view to shortening the issues and to reaching a stage where we can say that we're ready to go on trial. Obviously that's a process, and we'll progress that as best we can. And I really appreciate the attitude of Tali's for accommodating us in this respect. So at paragraph 29, by way of a formal application, my lady, as your ladyship has said, I asked my learned friends, given that they had told me that Ms. Guria was no longer available. She previously was a representative in terms of Section 332 of the Criminal Procedure Act. Your ladyship will know that for the past couple of hearings, their representative has been absent with consent. And we now have been informed by our colleagues for Tali's, accused number 2, that Mr. Pietermaritzburg Durand, as indicated in the minute, is indeed in the process of being appointed by Tali's as an agent or representative in terms of Section 3322B of the CPA. And looking at the provisions of Section 3322B, it is for the state to apply to the court when an accused becomes unavailable for whatever reason. It is for us to apply to the court to replace him. And we, with the consent of Tali's, do indeed make that application. And we've agreed that he will be present at further proceedings. And
that's for the substitution of Mr. Durand.
In terms of Section 332, in brackets 2 and brackets B. And my learned friend has given me the resolution, so we'll settle this between us. We'll make sure that we're happy with that, and I'm sure we'll make sure that both parties are happy and that we satisfy the court that is correct. So then I ask the court to order that Mr. Durand be substituted. The court ladyship can address that in due course. Now, my lady, the final issue then is in relation to Mr. Zuma's absence from court today. I must say that it's disappointing that despite, and I should say that we are reminded this week, I mean, yes, or last week, my learned friend, Mr. Mancha, about our invitation, please to give us medical certificates, evidence, whatever he chose to give us, to put us in the picture relating to what the illness is which prevents Mr. Zuma from being present today, and why it is necessary that he should have to seek medical treatment abroad, in broad terms, because I submit, my lady, that in terms of Section 170, it is a criminal offence for an accused not to be present in court, having been warned by the court on the 15th of October to be present today. And the procedure, as we understand it, my lady, is that the court has to hold an inquiry relating to any justifiable reasons for the absence, and if it's medically related, obviously we are obliged to assist the court to evaluate the nature of any medical evidence. My lady, that is what is the case in respect of any accused, and we treat all accused equally, and thus the procedure is the same in any court in this country, from the magistrates' courts to the regional courts to the high courts. When an accused is absent, there is an issue and an inquiry has to be held, and the court has to be satisfied in the end that the absence is justified. The procedure in respect of the postponement of proceedings is, without any exception, that being criminal proceedings and being that the accused remains under the jurisdiction of the criminal court, the postponement has to be subject to the issuing of a warrant of arrest for an absent accused. I know there's a debate in the law about whether the warrant of arrest can be held over, the execution of a warrant of arrest can be held over or not. I think sensibly the law allows, and it is an invariable practice of these courts and all courts in our country, except I think in the Northwest, if I'm not mistaken, that warrants of arrest may fairly be, the execution of warrants of arrest may fairly be suspended, pending the result of an inquiry which might be at some future time. So that I submit is the general procedure. So we ask, in the circumstances of this case, that the accused is not here, admittedly so, he's in fact not here, that a warrant of arrest be issued at the conclusion of these proceedings, that a warrant of arrest be issued. The suspension of the execution of the warrant of arrest, and when the inquiry relating to his medical condition should be held, is a matter which the court will determine.
Is there a limit to the period of suspension?
I don't think so, my lady.
I understood that it might be 14 days in the past.
Yeah, well,
certainly that was a practice, but
I
don't know whether that is...
That is the practice, and that is what the state has in mind, that the inquiry must be held fairly soon. And there's another aspect of this issue which I wish to address, my lady, and that is this. We were informed by my learned friend, Mr. Muncher, quite fairly. I would submit on the 15th of January of this year that his client would not be here today. Mr. Zuma would be absent, and he would be abroad, and it would be for medical reasons. That is as much as we know. As I've told the court, we immediately on the 16th of January invited them, please, in advance, to give us medical certificates or evidence or whatever they intended to produce today before your ladyship, so that we would know what to do about it. We might very well accept that Mr. Zuma is gravely ill and needs urgent medical attention here or abroad, whatever. There's no reason to think that may not be so. There's also no reason to doubt my learned friend's word. We accept his bona fides. That is the information which he has. The problem is, my lady, that as with any accused, the word of counsel and indeed the content of medical certificates is not without more simply acceptable as sufficient justification to relieve that accused of the duty of being in court. And in this case, I've been informed, my learned friend, again fairly, and I have had discussions this morning, we're informed that Mr. Zuma did indeed leave the country sometime after the 23rd of January. So by the time he left the country, the invitation to Mr. Muncher on behalf of Mr. Zuma, the invitation from the state to please give us some idea of what is going on, what his condition is, and why he has to go out of the country, he received that invitation, and that invitation has been ignored.
Yes, I get it.
So any medical condition which precipitated his leaving the country with or without whatever medical personnel, that condition was diagnosed, and the witnesses and medical personnel available to give that evidence were in the country and available to my learned friend, such as our request, our invitation to them, please to put us in the picture, could be answered, but that was not answered. And that I submit redounds to the discredit of counsel for Mr. Zuma and Mr. Zuma's legal representatives, and I submit that your ladyship will take that into account in judging what should be done about the absence of Mr. Zuma. I should also put on record, as I think I'm entitled to, my learned friend will either hand up or apply for some procedure to make known to your ladyship that he has a medical certificate. He will address you on the content. I'm not going to, but as far as we are concerned, we have had sight of such certificate, but it is insufficient for our purposes, and I've informed Mr. Muncher of that. I think no more need be said about that, except that in the circumstances that the state is not in a position to fairly to help the court with the contrary view, if there is such, or with an evaluation of the medical evidence with a view to consenting to his absence, with a view to agreeing to a long postponement, with a view to suspending the application for the execution of the warrant. All of that, we as a state are at a disadvantage of being able to assist the court. And that being so, the application will be made and has been made for the issuing of the warrant.
So roughly you're asking for 3 orders. 1, the substitution of Mr. Durand, the issuing and staying of the warrant of execution for a period that you want me to determine, and thirdly, that the substantive trial be scheduled for some time in April, or at least the criminal matter be adjourned for some time in April, pending the finalization of the appeals, hopefully by that date.
Yeah, there's just 2 glosses on that, but
Yeah.
we don't at this stage ask that the issuing be suspended because we are not satisfied, and we think we should have been in a position to be satisfied now. So I don't know what my learned friend is going to present.
Let's hear what he has to say.
So I reserve what our application will be in that respect.
Okay, good.
And secondly, just the date. The date, my learned friend, Mr. Mancha, has said that he would prefer a date in May. The 6th of May, I think we've agreed that all the parties are available on the 6th of May. We don't like the long postponement, but nevertheless, the 6th of May suits all parties.
It might also be out of our hands, depending on what the court rules on.
So for the criminal matter, the 6th of May suits all parties, and that is the application.
Okay.
As far as the provisional date for the criminal proceedings are concerned, whether there should be another date for the inquiry, depending on what evidence that will
Let's
depend
deal
on
with that
the
separately.
submissions.
Okay.
Yeah, and finally, there was just one other point relating to the medical evidence. Obviously, we agree with my learned friend, Mr. Mancha. It is quite reasonable that issues of the health relating to any accused, and particularly a high-profile accused such as Mr. Zuma, I agree, there are issues of privacy and sensationalism of press, invasion of privacy, etc. We agree that he has a right that be protected, obviously. Therefore, any application by my learned friend that the matter should be dealt with in camera relating to the medical evidence, that when your ladyship is apprised of the nature of the medical evidence, we would go along with any application which seeks to protect Mr. Zuma's privacy, seeks to order the non-publication of any evidence, but that does not exclude the state, and it does not exclude the court. The state and the court, I submit, have to be apprised of the nature of what is going on, even if it's not in the greatest detail, but we need to know the basics of what is going on, what the prognosis is, and because it may be that we would want to hear in person from the doctor. We've done that in numerous cases in all courts in this country, where the doctor has to come and explain what's going on if we're not satisfied. But that is a process for the future.
Thank you.
Thank you, Madam.
Mr. Mancha?
Please accord, my lady. Let me begin by saying there are a few points that, before I get into the matter of whether your ladyship should consider to issue a warrant or not in terms of section 170. I just want to clear certain issues which my learned friend keep on canvassing them in every appearance that we make. Firstly, the invite to pre-trial arrangement. We have indicated to the state that such invite, as far as we're concerned, is premature. And on the basis that we have petitioned, and the basis of our petition is that we believe that there are reasonable prospect of success in the matter. That's number one. Number two, given President Zuma's position that he cannot afford to deploy resources on a proceeding that, according to him, might not happen. So the reply from President Zuma as far as the invite for pre-trial. It has been done in good faith without being obstructive, if my learned friend is trying to say obstructive. My lady, when a person makes a petition and raises the issues that we have raised in our petition, President Zuma believes that a higher court will vindicate him. So the answer is along those bases rather than to obstruct. Then the other point that the state keep on raising all the time is that they invited President Zuma to join an application to the Concord. Clearly, the circumstances and the issues that Mr. Zuma is raising in his matter are not entirely the same with what the second accused is raising. So he is entitled to approach a forum that he believes he will get a legal redress. So again, his route to petition the Supreme Court of Appeal again is done not as obstructing anything. So it doesn't make sense that the state will keep on repeating this as if there is something wrong if a litigant chooses to approach a higher court in which such higher court is competent to give the relief that litigant seeks. So moving to the matter of President Zuma's sickness. It is true, my lady, we have addressed a letter which I beg leave to hand to your ladyship. The letter dated the 15th January.
I assume the other sides have.
My lady?
I assume the other sides have copies of it.
Yeah, they do, my lady. They do. In that letter, my lady,
Yes?
it has been a public knowledge ever since last year, late October and early November, when President Zuma could not honor the invite to the Commission of Inquiry, where he indicated that he was hospitalized in Durban in the week of 1 week in October last year. He was meant to appear before the commission. He couldn't do so, and he was prevented due to illness. But it's also a matter of public knowledge that in mid-November last year, his medical team decided to take him out of the country to seek medical treatment. And then he returned sometime in December last year. In order for him to return back to the place where he's receiving medical treatment on the 23rd of January 2020. During the week of the 7th of January, President Zuma underwent 2 operations in Pretoria. And given his age and the fact that he did not recover much quicker, as
So
far
when
as
did he undergo the operations?
in Pretoria.
A date? Did you mention a date?
My lady, I think one operation was on the 7th of January. I think the other one was on the 9th of January, subject to correction, of course. But it was within that week. So he was hospitalized again, and that affected the timed departure of the 23rd of January. Given the nature of the 2 operations, given his age, that you need to optimize him before he can travel. He eventually traveled on the 27th
27.
of January. So the letter that I've handed to you, my lady, we indicated to the state on the 15th of January that President Zuma won't be available to appear in court due to the fact that he has to continue his medical treatment abroad. We then had correspondences with the state. As my learned friend has indicated, he had no reason not to believe the word from President Zuma's representative that indeed he was not going to appear in this court today. More so, at that stage, my lady, it was a matter of public knowledge that the former president will be out of the country to continue his medical treatment. So it was the right thing to indicate to the state that he will not be available to them. I will get into whether the request by the state and the attitude by the state was reasonable or not under that circumstances. I will do so, my lady, when I ask you in terms of how to exercise your discretion in terms of 170. Your ladyship is aware that the President of a Republic and former President of a Republic medical conditions is a matter of state security. These are matters handled by the military. The people in charge of the President and former President health is from the military doctors. The military doctors saw it fit, given the condition of President Zuma, that he received medical treatment in a jurisdiction where he is. Indeed, they had indicated in a note that I beg leave to hand to you. I will hand over to my lady an original note from the military hospital.
Let's give these a marking. Your letter is dated, shall I say, Exhibit 1, Exhibit 1 dash 4 to 20, so that it doesn't get mixed up with all the other exhibits.
I'm indebted to you.
Right? So and this will, second document is Exhibit 2, 4 to 20. It's marked as that. I take it, Mr. Downer, Mr. Mr. Zuma, that you've seen this document? Copies of it at least.
My learned friend, Mr. Munch, did show us a copy in chambers earlier today. Might I just say that might I just have a look at the certificate, my lady, because I don't have a copy with me at the moment. So, my lady, this certificate, which my learned friend seeks to hand out, is as he's described, but might I just say that under layman's diagnosis, it says medical condition.
Okay, I just want you to look at it and you can address me later.
And might I just say that I'll address your ladyship as to their disability and as to our attitude to this. Thank you. Thank you. But we don't necessarily accept that it is admissible.
I get it.
As more. Thank you. As such.
So Exhibit 2 is the original SAMHS prescription and duty restriction form. Yes, you will tell me more about this.
Well, my lady, I'm not sure if I had the state correctly, that a medical note from the military.
Sorry?
My lady, I'm saying, I hope I didn't hear the state properly, that they want to dispute the admissibility of a medical note with an original stamp from our military. Well, I will deal with that issue, my lady, as I go further. Well, my lady, that medical note
Yeah.
has indicated the return to be on the 30th of October 2020.
30?
30 April 2020. My lady, may I say, as I indicated before, that the health of a former president, the health of a president, as a matter of national security, is a matter of our armed forces. The doctor who is in charge and the doctor who has appended his signature is a doctor attached to our military, to the military.
Who is
hospital.
that? Is ZK Moteni?
Indeed, my lady.
Is that the
Indeed, my
doctor?
lady. Indeed, my lady. So on the faith of it, my lady, it will be absurd for a state to doubt admissibility of a medical note stamped by our military, unless if the prosecution team does not represent the same state that this military resides. But I reserve my right to respond to whatever submission my learned friend is going to make on that issue. Well, in short, my lady, that is where we are in terms of the medical condition of President Zuma. But can I now address your ladyship in terms of the submissions made in respect that a warrant of arrest must be issued and must be executed with immediate effect? Meaning,
Sorry, before you go on there, what must I make of this document which says that it's a pharmacy copy? What is that?
well, my lady, my submission to that is the document is titled Medical Confidential. The second submission is, my lady, this is the format that our military hospital use. My lady must understand that this is not a sick note from a private doctor. This is a sick note from a military hospital where they have got standard form to use to give information of this nature.
And what does HCP stand for?
Well, I think my submission, my lady, is the purpose of this medical note from the military hospital is to show your ladyship that President Zuma, for reasons of receiving medical treatment in a foreign jurisdiction, he's not able to be in this court.
Sorry, I just want a simple explanation of what HCP means. What is it? What's it an acronym for?
Well, my lady, I think maybe both of us, we are seeing a medical note from military hospital for the first time. For me, it is for the first time to see this. So I cannot actually explain to your ladyship the detail of the code that the military hospital uses in the form.
What also troubles me that it says there layman's diagnosis in brackets with consent of patient. I don't understand that either.
Well, my lady, I think that can be simply resolved by the doctor in question. He can, of course, explain it in a language that your ladyship can
Is he here?
understand. Indeed, my lady, the
Is the
doctor
doctor
is
here?
not here. The doctor is with the president, where he's receiving medical treatment.
Well, I need to make a decision today, and I need to understand this document, so you need to help me do that.
Yes, my lady, let me help you to do that. Firstly, my lady,
So you can't help me with what it means, layman's diagnosis,
well,
with consent of patient.
my lady, let me help you with what that document means.
Well, that particular thing
Well,
that I mentioned to
I
you,
might
layman's
not,
diagnosis.
my lady, help you with the abbreviation and the terminology they use, but I can help you to explain what this document means. This document is a sick note. That's what it is. And your ladyship will know that there is no, even in courts,
It's a no, there's no?
there is no standardized format in which how sick notes should look like. And here we're dealing with a sick note from the military hospital, where they've got their own process and protocol, and they've got their own language, whatever the case is. But to explain this document to you, my lady should look at the original stamp from the military hospital.
Yeah.
It is an original stamp, my lady.
It is an original stamp, but I can't see a date on it, or, but, yeah, there's no date on it.
Well, my lady, my submission is, it is an original stamp from the military hospital. The particulars of the doctor are given. It does say one military hospital. It does indicate the duration in which this particular person would be receiving treatment. And I
What was-
submit to your ladyship that your ladyship has got no reason to doubt a document with an original stamp from the military hospital, unless there's evidence that says your ladyship should disregard it. Should disregard it. So again, my lady, to answer that question, I would refer your ladyship on the matter of, it's a constitutional court decision.
Before you go there, I'm just trying to unpack this document. What must I make of the alterations, date from? It's not initialed. What must I make of
My
this?
lady, where are the alterations?
On my original copy, under the,
Which portion?
under date from, the heading date from, the alteration relates to the date. That is 2020-01-06.
Well,
The 1 and the 6 have been altered.
well, my lady, I think with respect, we are right in the beginning of the year. Some of us were still carrying the letters of last year. So I don't think your ladyship should make an issue where this one has been, it's not really altered, but I think one was writing, it was a 2, and then I think it's 1. But it's not really altered, but your ladyship again,
Well, I see what I see,
yes,
and what I see is that it's altered.
yes. Well, my lady, I should then take you to the Constitutional Court decision on a matter of,
Well, before you go there, Mr. Mancha, my difficulty is that if you want me to accept this, I've got to understand it, and you've got to help me understand it. And what I don't understand is the two things at least that I've pointed out to you. It's not your interpretation or mine that matters. It is what the doctor puts in here. I don't even know that Mr. Moteni is in fact a doctor. There's nothing to suggest from this that he is. And so help me understand that. Show me the proof. And if you want me to accept this, give me a precedent where this has been done in the past that helps me say, well, there's a precedent that I can follow. But the way it is, I have some difficulties.
Well, firstly, my lady, you have no basis to doubt whether Mr. Muteni is a doctor or not. You sit before your eyes with a document that says a military hospital.
Does he put his medical registration number there?
Well,
Which is how doctors usually sign off.
my lady, there is a number 91006601, I think MC.
What does that mean?
Well, I would assume the way it was placed next to his initial and his surname. That would, in most probably, his medical number.
Yeah, Mr. Mancha, I just want to make it clear that I'm asking these questions to understand.
Indeed, my lady.
I have, as you say, I have no reason to doubt Mr. Moteni might well be a doctor, but I've got to see it here. And you need to help me, you need to point this out to me because I can't see it. Usually they sign MCBH, don't they?
Well, my
And there's
lady,
usually a doctor's
my lady is
stamp too.
referring to the ordinary sick note that we collect every day from private doctors. This is a different matter, my lady. That's why they use this form. And I'm submitting to you that in this form, the number that I've just read to the ladyship,
Might well be his registration number.
indeed, my lady,
Are you saying it is or it might well be?
well, under the circumstances given his initials and surname, it should be his registration.
But we don't know that as a fact. Do you know it as a fact?
Well, my lady, we have to accept.
Well, you accept that.
Well, I'm persuading you to accept.
Okay.
I'm persuading you to accept that it can only be his registration number. And again, my lady, your ladyship has got no basis at all to even doubt that Dr. Monteni is indeed a doctor with the military hospital. And your ladyship, this can even be resolved by a short adjournment where this matter can be clearer. This is a doctor from the military, from the state, and here the state is here. This matter, if your ladyship wants clarity further, these proceedings can be adjourned and we can clear to the satisfaction of your ladyship that indeed is a doctor attached to the military hospital, is a doctor responsible for the medical condition of the former President Zuma, and any other issue that your ladyship might have as far as this form is concerned, the format, the particulars. These are matters that can be clarified to your ladyship through an adjournment. We can discuss the things, and whatever clarity your ladyship wants in terms of whether this is legit or not, that can be done. So I would submit that if your ladyship is inclined not to, or your ladyship does not understand the detail of this form, I will then submit to your ladyship that the appropriate way to do would be to adjourn and clarify those issues. And I must then indicate to your ladyship that the doctor in question is available to even clear with your ladyship if there is any question. But of course, given the time zone difference from where we are and where he is, I'm not sure whether he's up, so we can actually even call and take that form and to verify all of this. And besides, this is an official document. The nature of it can also be verified as the prosecution represent the state, it can be easily be dealt with. The lack of understanding of your ladyship should not be a factor to then say, well, I don't understand this medical note, and therefore I'm not sure as to the absence of the accused. That matter can be verified. My lady, I must also venture to say that my learned friend Mr. Downer indicated that we must treat all the accused equally and fairly. My lady, if you look at the appearance record, even when he was not required to appear. For many years, he has never missed court appearances. And again, he's the first accused in this matter. There's a second accused. There's a submission which my learned friend made to you to say, no, second accused, we agreed that second accused should not appear. And if you look at the appearance record, my lady, many instances, second accused has never been in court. And if you look at the law, my lady, an accused is an accused. It doesn't matter whether you corporate accused, but an accused is an accused. If you look at our constitution, it talks of an accused. It talks of the right of an accused. It talks of equality before the law. Why should accused number one, despite the fact that he has been regularly attending this court, without any fail, that he is, as a matter of fact, receiving a medical treatment in a foreign jurisdiction, he cannot come to this court. Why should the state cannot treat him the same way as they treat accused number two? There's no accused number two before this court. There was no accused number two in the previous occasion. If the state is prepared to accept the absence of accused number two, but not prepared to accept the absence of accused number one, why different treatment to this accused? What is it that is different from accused number one to accused number two? They're both accused in the same matter, facing similar charges.
Are you saying Mr. Durand is not in court?
My lady, there was no appearance. Look, I can't say for today, but there was no appearance in several occasions.
Well, today, I mean, I asked Mr. Downer whether Mr. Durand was in court.
Well, today I don't know, my lady. Maybe he is.
Is Mr. Durand in court?
He's present.
Please indicate who you are, Mr. Durand. Is that you?
Yes.
The person in the dock.
I'm indebted to your ladyship. But again, my lady, you can look at the appearance record. My lady, you can look at the appearance record and the statement that my learned friend has just indicated to you. In number of occasions, accused number two was not represented. That's a fact. There was no talk of warrant of arrest. There was no talk of warrant arrest. So, I will still address you on the jurisdictional factor in terms of 171, what your ladyship should consider. But this quest for warrant of arrest, my lady, is nothing else. It's spiteful, it's vindictive, it's persecution of President Zuma.
Ms. Mencha, as you know, it's the first time I'm presiding in this matter. The history of what went on in relation to who attended and so on is not top of my knowledge base at this point in time. So whatever the reasons they had for that, I'm not aware of. But if you're saying that there has been a difference of treatment between the two accused, that may be one factor. You are using as a comparator accused two in the case, that a different treatment was meted out to accused two. My difficulty is, one, it is my discretion. And it is my discretion as to what I do with the absence of an accused. It is my decision that has to be consistent with the law. in the audience would be people who were in my court on Monday when I had to issue a warrant of arrest that I had stayed previously because a medical certificate had not been forthcoming. Now, that is another comparator. What society would think if I allowed Mr. Zuma to be absent from court without a medical certificate that meets the requirements of a medical certificate. I'm not making any judgment on the authenticity or the validity or the sufficiency of Exhibit 2 at this stage. But I just want to explain to you that I have to be consistent with the rules of court, with the practice of the court, and with what society expects of me. It might well be that it's public knowledge of Mr. Zuma's medical condition, but you will agree what the dangers are of me taking into account public knowledge and public information. We have rules. It's got to be evidence. It's got to be legal materials before the court for me to make a decision. What goes on out there in the media is hugely dangerous if I were to take that into account. So I just want to sound that out with you now and indicate to you how I think about things so that you can address my thoughts.
Well, my lady, I think I've already intimated to your ladyship how the clarity that your ladyship seek in terms of this medical note can be addressed. And of course, I remain there, that can be cued by a short adjournment or an adjournment where this matter can be clearly conversed to the satisfaction of your ladyship. I remain there, madam.
Okay.
But getting to the matter of the public, my lady, the people know that President Zuma, with no faith, he has been coming to his court. And the people also know that he's an elderly man who is out of the country receiving a medical treatment. To issue a warrant of arrest under those circumstances, my lady, it won't be in the interest of justice. It will be putting the administration of justice in disrepute, because people will ask, what kind of courts are these? Where there's no sensitivity? Yes, there's a medical certificate submitted. Yes, there's every proof that President Zuma is out of the country receiving a medical treatment. Yes, there's an offer that the matter be adjourned so that the court can satisfy itself with every single question that the court might have, so that the court can exercise its discretion in terms of Section 170. And if I can take your ladyship to Section 170, subsection 2, the court may, if satisfied that an accused referred to subsection 1 has failed to appear at the place and on the date and on the time to which the proceedings in question were adjourned, has failed to remain in attendance at such proceeding, so adjourned, issue a warrant for his arrest, and when he is brought before the court, a summary inquiry. Okay. It went further, a summary inquiry into his failure to appear before court. So, my lady, where we are now, your ladyship is appraised with the reasons of the absence of this accused. So, what are the jurisdictional factors that must be present before a court can issue a warrant? Your ladyship, we all know that it's a discretionary matter. Your ladyship has to assess the factors and in the Constitutional Court decision that I'm referring your ladyship to, which I can hand over the case in a matter of Singo versus the state, the then Chief Justice Nogo, an accused person who culpably failed to comply with a warning to appear in court commits a criminal offense. So this decision, my lady, deals exactly on a matter that I want to canvass at the end, which is
You're handing that up.
what standard should the accused meet in his explanation of absence? And so let me just make sure it's the only one. The most important thing, my lady, that I'm referring you to there is the standard that the accused has to meet in explaining the absence. You would see that the Constitutional Court said if there is a reasonable doubt, the explanation of the accused as to the absence must be believed. And I'm saying, my lady, apart from the fact that I've made an offer that we adjourn to clear whatever concerns that your ladyship has, but in light of that decision, my lady, firstly, there's no culpability on the part of President Zuma. We know he's receiving a medical treatment. And we also know that that did not start this February or the last January. We know that that has started last year, as early as October. And we know that it's not for the first time for him to leave the country to receive a medical treatment in the jurisdiction where he is. It is for the second time, is a continuation of the treatment that he has started last year. So, my lady, those are the facts that the prosecution cannot disprove. And those are the facts that whether there's a medical treatment or no medical treatment, there is a reasonable doubt that must benefit the accused, that his explanation should be accepted. So, the jurisdictional factor, my lady, it is not only the absence of the accused, but the reasons of the absence of the accused. And, well, I invite the prosecution to tell your ladyship that indeed President Zuma is not receiving this medical treatment. There is no such evidence. And in the absence of that, my lady, therefore, he's not at fault. People don't plan to be sick. And, my lady, we're talking about an elderly man here who is close to 80 years. It's not uncommon. We also know from our experiences at home that our elderly grandfather and grandmothers, at that age, there are issues. So, it's not uncommon that a man who has traveled the journey that he has, and a man of his age, would, of course, fall ill. And there's no evidence, my lady, I repeat again.
No, don't repeat yourself. I've got another trial and we've got load shedding, so let's move it on.
Okay. So, your ladyship has to exercise your discretion, and there's one overriding factor that your ladyship should be guided by when exercising your discretion, and that is precisely the interest of justice. The interest of justice will require that the authority of the court must be protected and maintained at all times. That people who are warned to appear in court, they must appear in court. If they don't appear in court, they must know that there are consequences. Your ladyship must, in exercising and determining the interest of justice, the administration of justice, it has to give confidence that our courts are impartial, that our courts treat people, all people before them, equally. Where there's first accused and second accused, they're given the second treatment. And I've already alluded to your ladyship that on a number of occasions concessions were given.
Are you repeating yourself?
Well, my lady, I'm just trying to give factors that constitute what I submit are interest of justice. I'm sorry if I've repeated myself. So, there has to be, in exercising that discretion, your ladyship has to be convinced that these accused before you, there's nothing that suggests a reasonable reason why there is absence. And I'm saying to you, we cannot pass that test, that before you there are no reasonable reasons that suggest why this accused is not involved. So with this, my lady, I sum up by repeating myself with the invite that whatever problems you have on the medical note, this offer has been made in chambers to my learned friend in the prosecution. This can be clarified. This is one state.
Okay, Mr. Mancha, I must ask you please to sum up and not repeat yourself. I would like to move on to Mr. Roux, if you're done with your submissions. Is there any new point you wish to make?
Well, in conclusion, my lady, the jurisdictional factor that has to be present for your ladyship to exercise your discretion to issue a warrant of arrest are absent in this matter.
Thank you.
And secondly, the jurisdictional factor which has to be present for your ladyship to issue a warrant to be effected, their absence in this matter. As please the court, my lady.
Thank you. Mr. Roux?
Thank you, my lady. We have no submissions in the present proceedings, but to confirm that we have handed to Mr. Downer the resolution authorizing Mr. Durant to appear, and of course the state will revert if there's any difficulty.
Thank you. Mr. Downer?
Thank you, Madam Chair. I should try to be as short as I can. The lady, might I hand up our letter which we sent in reply to Mr. Muncher.
So that will go in as Exhibit
Thank you. Yeah,
3.
And my follow-up email, which will be Exhibit 4.
4 to 20.
Yeah, might I just quote then from, and the first letter is from the DPP herself, Advocate Elaine Zungu.
So that will be Exhibit 4?
Yes, and she says, I'll hand it up now, my lady. I apologize, I don't have a copy yet. Your client's absence from court because of his ill health and any postponements on that account are, however, matters for the court to determine according to relevant medical evidence. This is the 16th of January. The state's attitude to any applications that you may bring on your client's behalf concerning this issue can likewise only be formed on the basis of medical evidence. You're accordingly invited to provide me urgently and in advance with copies of any medical evidence that you intend presenting to the court in order that the state may consider its position. That's Exhibit 4 and Exhibit 3 and Exhibit 4 is the follow-up email which was sent by myself to Mr. Munch. I'm not going to quote it. It just reminds him, please send it because we need the evidence. Now, my lady, my learned friend, Mr. Muncher, accuses the state of being vindictive.
Of?
Being vindictive. Might I say we deny that? We're not. We're treating this accused as any other accused. Might I just say that it is extraordinarily uncollegial to leave unanswered pertinent invitations from the state in good faith to be able to assist the court with medical evidence, which clearly is necessary to explain his absence from court today. It's uncollegial that they go unanswered, and therefore, in answer to me, my learned friend Mr. Mancha invites the court to grant him a postponement in order to clarify issues relating to a so-called medical certificate. And I say so-called advisedly. My lady, why are we swimming through mud now when since the middle of January, my learned friend has been put on notice, we need medical evidence. And in order for us to assess our position and, if necessary, admit consent to the admission of the evidence without calling witnesses. My lady, as we now have that so-called certificate before the court, the state does not consent to its admission. It remains hearsay evidence. The witness is not before court. It is evidence by a witness who's not here. It has no evidential weight whatever. It proves nothing. Moreover, it raises many more questions than it answers. Who is the doctor? Where does he come from? What is the so-called illness, medical condition? Why is it a layman's diagnosis? And so on and so on. These are questions which I want to put to the doctor, and if he could explain them, well and good, but it should not have been necessary to reach the stage where we're sitting in court now, quibbling about the terms of an inadmissible medical certificate with an added, desperate application before your ladyship that the matter should be postponed to clear up these issues. They could have been cleared up on the 16th of January. If I go through my learned friend's address, he says that that we know that his client is sick and he's been here, there, and everywhere in hospitals, etc. We don't know that. We've heard reports in the media, and moreover, we've heard submissions from my learned friend. They are not evidence. We do not know. We want to know that. I would love to know that. The court would want to know that. The state would like to assist the court to evaluate, put in perspective, judge whether, in fact, these things are so. What is a medical condition, etc., etc. So that being so, we oppose the application for a postponement now to clarify this medical evidence. My learned friend has known for weeks. He's always known what the position is, because that is the law. It's not rocket science. It's simple law which is practiced in the magistrates' courts, and we know here in these courts before your ladyship yesterday. Any lawyer knows that. So in other words, to now have reached this position with all that background and the extraordinary uncollegial attitude of my learned friend, which he then crowns by calling us vindictive, it really is unacceptable. And so our opposition to a postponement is clear. We absolutely oppose it. It is in line with the Stalingrad defense.
Yes, let's get on with the order that I'm supposed to make.
So the order which I ask your ladyship to make is, in the absence of any medical evidence, we are left with section 170. Section 170, my learned friend says, has not been satisfied with jurisdictional aspects of section 170 is simple. It says, the court may, if satisfied that an accused referred to in subsection 1, that's the person has been warned to appear in court, has failed to appear at the place and on the date, that's today, and at the time, that's this morning, to which the proceedings in question were adjourned, was failed to remain in attendance, so he's never here, and he has not remained in attendance. At such proceedings, so adjourned, issue a warrant for his arrest. And when he is brought before the court, and there's an inquiry held as to his culpability, that is the medical evidence, that is why he wasn't here, was he sick, could he appear, could he not appear, then at that stage, at the inquiry, the court determines his culpability, but that is at a later stage. So the issuing of the warrant of arrest has one jurisdictional fact, or two. Was he warned to appear today? Yes, he was. We're all at Idem. Number two, is he here? The answer is no, he is not here. Those are the two and only jurisdictional requirements for the issue of a warrant, and so the warrant for the immediate arrest of Mr. Zuma, so the state's application goes, should be issued today. What my learned friend chooses to do as a result of that, and give further medical evidence to the court, to the state, no doubt we can reach an accommodation, I hope, if he is indeed sick. There's no reason to doubt that he is sick. Perhaps he is, perhaps he isn't. We just simply don't know. But to continue this obfuscation in the light of these serious invitations and reminders, I submit it would serve no purpose for this, and that also relates to the court, because we have said to my learned friend, we the state don't make the decisions. We just, as officers of the court, we want to assist the court.
Right.
If you don't allow us to assist the court, then it impinges on the authority of the court, and that is our application.
Does Section 170 say anything about suspension of the warrant or any time limits on the suspension?
No, it doesn't, my lady.
And what informs the practice that it be for a short duration, just to ensure that the accused is secured for trial?
Well, I think if you read the cases which are cited in Detroit, and I've read them quite length, it's not necessary to dwell on them. The practice has always been that where there's no reason to think that there's any culpability on the side of the accused, which is absent in this case, there are indeed big questions, then it makes sense to stay the issuing of the warrant, so that if an accused is sick and he can come to court tomorrow, then he can explain it all, and there's no need for the police to go and arrest him and drag him to court, etc. The courts have questioned whether that's competent, because 170 doesn't say that. So the salutary practice of suspending it for 15 days, whatever, is good. And
well, because we don't know what Mr. Zuma's condition is, and assuming, and the possibility that he might be quite ill, that he is not immediately available. We don't know when he might be. What are your views on the warrant being issued and suspended to the date when his counsel says, or this purported medical certificate says he would be available, and that's on the 30th of April or shortly thereafter? You've mentioned the 6th of May as a return date.
I would submit that given the difficulties with the evidence that we face today, we have no evidence, and there should be evidence. If I just go through my little friend's argument there, he's been in hospital here in the country, he's been treated by doctors here, he's been operated here in South Africa. All these certificates are available and have been available for a long time. So to give a period from now in early February to early May, that's April, May, that's a good 3 months.
Well, all of that might well be available. What I'm worried about is Mr. Zuma's ability to participate in that process and to instruct his medical team on what to release, what not to release, how to release it, and so forth, might be compromised if indeed he is ill. That's my...
Yeah, but that is a problem of their own making, and it could have been avoided, and that can't be accommodated. So I submit the furthest that we would go in our submissions is to say, in the alternative, our first submission remains, that warrant must be issued today. And that is then for my learned friend, given his attitude, to amend the attitude and to come to the party and assist us. And there's no reason to think we won't assist him. Right? And that being my main submission, the alternative submission in accordance with your ladyship's suggestion, is suspend the issuing of the warrant for 14 days. That would give quite sufficient time. And there need be no appearance at the end of the 14 days. The warrant simply gets issued by arrangement between your ladyship and the registrar, etc. The warrant gets issued. If in the interim there is satisfactory evidence, which my learned friend Mr. Mancha has available, because of all the reports in this country which have been, etc., and we get the outline of what the problem is, what has been going on, and what the prognosis is, then we could approach the court, and we could then the warrant would then be cancelled or held over until the 6th of May, because the warrant would have to, in any event, to remain current until the 6th of May. So I think those are our submissions.
Yes.
If I may just assist in the question.
Yes, Mr. Du.
The 14-day period is a determined forfeiture of bail period.
Yeah.
That's really...
Thank you. Thank you. That's helpful. There's no question of bail or anything here.
I assume it's not.
Yeah. Right. Judgment. In this matter, which has a long history, procedural history, Counsel for the State outlined the progress with regard to various appeals. The decisions of the appellate courts are outstanding. That in itself justifies an adjournment of this matter to an appropriate date when the decisions of the appellate courts would become available. It is suggested that April or May might be possible dates for that, for those decisions to be available. However, there's another more troublesome issue, and that is the absence of Mr. Zuma from attendance in this court. It is common cause that he was warned to appear today, and it is also noted that he is not in attendance, and so the jurisdictional requirements of Section 170 of the Criminal Procedure Act have been satisfied. The question is whether his attendance or his non-attendance should be excused. Counsel for Mr. Zuma, Mr. Mancha, suggests or submits that he should be excused because he is currently receiving medical treatment outside the country. In support of this, or in an attempt to support his submission that Mr. Zuma is unwell and in need of medical attention, he submitted Exhibit 2/4/2/20. This is a document titled Medical Confidential, and in brackets is marked pharmacy copy. It bears an original stamp of the military hospital without any date attached to the stamp. Furthermore, the Section B of this form uses an abbreviation HCP, which has no explanation on the form, and Mr. Mancha was unable to help the court with an explanation. Below that is written or typed as part of the form, layman's diagnosis in brackets with consent of patient, close brackets, and in handwriting appears the word medical condition. That too does not elucidate what Mr. Zuma's condition is. In fact, it is puzzling that there is a reference to a layman's diagnosis, and what the patient's consent is quite unclear. There is also apparent from the form in the section relating to the date of sick leave, the date is altered to be January 6th. There's no initialing of that date. It is not clear that Z.K. Moteni, who apparently signed this document, is indeed a registered medical practitioner. Mr. Mancha submits that the numbers appearing about his name would be his medical practice number. That might well be the case. However, that is guesswork. Mr. Mancha is assuming that, and the court does not have it as evidence or reliable evidence of the status of the person signing this, or purportedly signing this Exhibit 2. So the court accepts that Mr. Zuma might well be unwell. There is nothing to suggest that he is or is not. Now, in this regard, what goes out in the public domain, in the media, and what is exchanged between counsel is not evidence. What this court requires is evidence, some authentic, reliable proof that Mr. Zuma is indeed ill and when he will be available to stand trial. Not only is that evidence necessary to determine his availability to appear again, but also it's necessary to determine how the trial will be conducted, what interruptions might be expected, if any, during the trial, what accommodations and arrangements might need to be made for him. Now, none of that is before this court. None of that helps the court to administratively prepare itself for what will be a very important trial. It is also the duty of this court to ensure that everyone is treated equally under and before the law. I mentioned that yesterday I had to issue a warrant of arrest for a person who did not appear in court, who had, after being warned of the need for a medical certificate, chose not to produce one. Those persons are in this court. The comparison between Mr. Zuma and anyone else, in particular representatives for accused 2, is not the only comparison. The comparison that the community will make is how does a court treat Mr. Zuma in relation to everyone else. And so it is standard practice in this court and in every court hearing a criminal trial that if an accused is not in attendance, if an accused has failed to produce a medical certificate, and in this instance, counsel for Mr. Zuma was notified in advance in the middle of January that this document or that sound evidence is required to justify his absence from court, and without that evidence, this court cannot do anything else but issue a warrant of arrest. However, in doing so, the court takes into account that Mr. Zuma would be an active participant in how the warrant of arrest is addressed going forward. His medical condition may be such that his participation might be impaired. Now, the order that I will grant will be one that will not bar the parties from putting forward or exchanging information or engaging with each other should they find medical evidence or information to the satisfaction of the prosecution that Mr. Zuma is unwell, and that's what his needs would be when the trial resumes. Those conversations can continue, notwithstanding the order I make. Finally, it is not only Mr. Zuma who is entitled to a speedy trial, it is accused 2 who also has that right. And as Mr. Mancha pointed out, the rights of accused are well stated in the Constitution, and no one accused should be preferred over the other. In granting the orders that I do, in particular in making and issuing the warrant of arrest, I do nothing more than what the law requires me to do in the circumstances. There is one other issue that needs to be dealt with, and that is the substitution of Mr. Durand. Let me get his name, full name, Mr. Pierre-Marie Durand, on behalf of accused, as a representative of accused 2. The order that I make, therefore, is the following. Mr. Pierre-Marie Durand is substituted as the representative of accused 2, Tale South Africa Pty Limited. Number 2, a warrant of arrest for accused one, Mr. Zuma, is issued but stayed until 6th May 2020, the date on which this matter will resume. 3, this matter is adjourned to the 6th of May 2020. Thank you. Let's take a short adjournment so that we can reconstitute the court. Just to clarify that the adjournment is to this court.
Thank you, guys. Just Mr. Richard.
Mr. Downer, Mr. Mancha, and Mr. Rue, I should just make sure for completeness so we don't have this debate again, that is that the accused number 2 is born to appear.
Yes.